At least 24 hours prior to the regularly scheduled meetings, public bodies must display public notice of the meeting by posting the date, time, place, and agenda for the meeting in prominent public view at the principal office of the public body or at the location of the meeting if no office exists. Public bodies may also post the date, time, place, and agenda on its internet website. Importantly, if public bodies have a website, they are required pursuant to 74 OS Section 3106.2 to display a schedule and information on the regularly scheduled meetings, including the date, time, place, and agenda. When reasonably possible, the date, time, place, and agenda of special or emergency meetings should be placed on the website as well. If a public body elects to use posting on the internet for notification, it must constantly maintain an email distribution system for dissemination of notices of public meetings. Emailed notices shall include, either in the body of the email or as an attachment, the date, time, place, and agenda for the meeting. Further, the emailed notices shall be sent no less than 24 hours in advance of the meeting, and a copy of this notice must be made available to the public in the principal office of the public body or at the location of the meeting during normal business hours. I generally recommend that all of my clients post hard copies of the agenda even if they have a comprehensive website that routinely posts the information required by the Act. If a system crashes, or if the information cannot be disseminated, the posted agenda provides proof of notice, typically with the signature of the clerk, that can be maintained into perpetuity. This redundancy is important, especially in the event of a challenge for violations of the Act. The 24-hour notice requirement excludes Saturdays, Sundays, and legal holidays declared by the state of Oklahoma. Particularly around the holidays, it can be challenging for public bodies to meet this requirement. Care should be taken to ensure that the state holidays are taken into consideration, as those may differ from those designated by the municipality. In addition to keeping track of the regularly scheduled meeting dates, many clerks review the calendars in advance and actually docket the date that the agendas must be posted, taking into consideration holidays designated by the state of Oklahoma and the municipality. This is a wonderful practice that should be encouraged by all attorneys representing municipalities. The Act defines special meeting as any meeting of a public body other than a regularly scheduled meeting or emergency meeting. Special meetings cannot be held without giving public notice at least 48 hours prior to the meeting. The notice must include the date, time, and place of the meeting in writing, in person, or by telephone to the municipal clerk. The public body must also cause written notice of the date, time, and place of the meeting to be mailed or delivered to each person, newspaper, wire service, radio station, and television station that has filed a written request for notice of meetings of the public body. This written notice must be mailed or delivered at least 48 hours in advance of the special meeting. In addition to the 48-hour notice requirement, public bodies must also provide the date, time, place, and agenda for the meeting by posting it in prominent public view at the principal office of the public body or at the location of the meeting if no office exists. As with regularly scheduled meetings, the 24-hour requirement excludes Saturdays, Sundays, and holidays legally declared by the state of Oklahoma. Importantly, only matters appearing on the posted agenda of a special meeting can be considered by a public body. As such, no special meeting agenda should contain an item for new business. In lieu of public posting, public bodies may post the date, time, place, and agenda of the meeting on its internet website. As mentioned above, if a public body elects to use posting on the internet for notification, it must constantly maintain an email distribution system for dissemination of notices of public meetings. Emailed notices shall include, either in the body of the email or as an attachment, the date, time, place, and agenda for the meeting. Special meetings require posting and email notices no less than 48 hours in advance of the meeting, exclusive of Saturdays, Sundays, and holidays legally declared by the state of Oklahoma, and a copy of the notice must be made available to the public in the principal office of the public body or at the location of the meeting during normal business hours. As previously discussed, I recommend hard copy posting to avoid any confusion with the statutory requirements and technology-related issues. Before reviewing emergency meetings, I would like to take a few minutes to discuss new business. The Open Meeting Act allows public bodies to discuss new business at their regularly scheduled meetings. New business is defined in the Act as any matter not known about or which could not have been reasonably foreseen prior to the time of posting. Before I began representing smaller towns and cities, I was militant in my use of new business and even requested that it be removed from regular agendas. My rationale was that availability created opportunities for incidental misuse. I also believe that due to availability for a special meeting with 48 hours notice, there was really no reason to make this available. Also, the spending authority of city or town managers generally allowed for resolution of issues that required immediate attention. As I began to represent smaller municipalities that may meet only one time per month, I began to appreciate the importance of new business as a tool for resolution of important matters. For example, one client had only one truck for servicing the town's utilities. The truck broke down after the regularly scheduled agenda was posted. It was important to get it fixed immediately, or employees would have no way to promptly address the needs of citizens. Consideration under new business was appropriate and allowed town officials to have the truck evaluated for repair. In order to improve transparency and create a record, I generally recommend ratification of the action at a future meeting. For example, in the case of the truck, the board ratified the decision to repair it as well as the expenditure for repairs.